We're going to work Senate Bill 205, and we'll have Chris explain the bill to us.
Thank you, Mr. Chairman. Committee Senate Bill 205 will provide a one-time authorization in Section 1 for the Chief Engineer to approve a complete application for the establishment of a multi-year flex account, or MIFA, if the water right otherwise meets the requirements for that multi-year flex account, even if the relevant base water right participates in a water bank. This one-time authorization would expire on December 1 of 2023. Section 2 would establish that a water right or any portion of a water right that has been deposited, enrolled, or placed in a safe deposit account in a water bank shall not be eligible to enroll in a multi-year flex account in the same year in which the right was withdrawn from a safe deposit account. Similarly, the water that has been placed in a safe deposit account cannot be withdrawn if the right is enrolled in a multi-year flex account. Section 3 would provide when a water right is bankable, saying that it's bankable if it's not currently enrolled in a MIFA. Section 4 would just consider those two new sections 1 and 2 in the MIFA statute. And then the bill would be effective upon publication in the Kansas Register. I'd be happy to answer any questions.
Any questions? Representative Sywert.
Thank you, Mr. Chair. Does this do anything to help get rid of the use it or lose it, or is this just put it off and you still got to use it up or you don't?
Thank you, Mr. Chairman. I don't know if maybe it directly addresses that problem. This does provide more flexibility in how some of these water management tools can be used and when they can be utilized. So indirectly, it could have an effect, but
Well, that's why I didn't understand the clarification, because the wording, the way it's worded, it doesn't tell me exactly what we're doing to do what we want to do with this bill. It's just wording in my books right now. I want to know if it does anything to get rid of keep saving water and not keep appropriating it when we save it. I'm using these multi-year flex accounts and then saying we're going to issue more permits.
thank you, Chair. I don't know if it has any effect on permitting per se, but it does allow a water right to be in a MIFA, which is a flexibility tool where you can go over and above your annual allocated amount used within a 5-year period. It allows some flexibility on if you have
All right, thank you, Mr. Chair.
As I understand this, it's a kind of a cleanup bill for the department or the Division of Water Resources. In December 11th to about the 31st of December, there were applications made to enter into a MIFA, multi-year flex account. It would not change the appropriation. It wouldn't change the use of anything, but it would give the producers somewhat more flexibility. But there were some users currently in the water bank that wanted to apply for a MIFA. This allows the Division of Water Resources to deal with those people in that short window of time period, I believe. Is that correct?
Yes, that's correct, Mr. Chairman. There was an Attorney General opinion that came out in January 6th of 2023 that said that water rights that have been placed in a water bank are not eligible for a MIFA. So this would not only allow those temporary applications while they were getting this Attorney General opinion, those would allow those applications to be processed, and for those people to get into a MIFA, it would also allow rights to participate in both.
Any further questions? Representative Fairchild.
Thank you, Mr. Chairman. I guess my question is just, why is this only applying to those users in that specific period of time? And, just as a general question, what would be the problem with just indefinitely saying that people could be enrolled in both the water bank and a MIFA?
Thank you, Mr. Chairman. My understanding was, for one, the temporary authorization was to allow those applications that were filled out last year up until the Attorney General opinion were kind of in limbo. And the Attorney General opinion said they would not be allowed to go through. So that the temporary authorization is to clean up that situation. Going further, my understanding was there was some sort of accounting aspect for why they wouldn't want both occurring at both times, but that would be more of a question for the Division of Water Resources.
We did have a hearing on this back on March 9th, and we heard from the people from the Division of Water Resources at that time.
Yeah, I probably should have asked that question then. It is something that occurred to me that why don't we just make this, make that permanent going forward, that they could apply for both of them. I never asked that during the hearing.
I believe at the time of the hearing, we had one oral proponent, a couple written, or those were proponents, I'm sorry. One proponent from the Division of Water Resources, a couple of written, and no opponents and no neutrals on this bill. And it was viewed as basically kind of a cleanup bill.
Yeah, I support the bill. I was just wondering why we, don't, just permanently allow people to have enter into both the water bank and the MIFA.
Any further questions? Representative Getz.
Thank you, Mr. Chairman. Was this, for this one, wasn't it for clarity's sake that they couldn't be in a water bank and a MIFA this for that time frame, and they were cleaning it up, but this establishes that they can't be in both, correct?
Thank you, Mr. Chairman. It would establish that they can't essentially use their water bank right. They can't withdraw, or the intent at least was so that they can't withdraw, but they can be enrolled in a water bank while in a MIFA. They just can't use that water right from the bank.
Okay. Thank you, Mr. Chairman.
Seeing no more questions, what is the pleasure of the committee on this particular bill? Representative Blacks.
Thank you, Mr. Chair. I make a motion that when the committee moves, that we move Senate Bill 205 out favorably for passage.
Is there a second? Representative Getz. Okay. Any discussion on the bill? Oh, Representative.
Thank you, Mr. Chair. I have a couple amendments. One I'm not going to bring today, but I would like to maybe discuss it a little bit for a future consideration. It's concerning municipalities and their relationships with GMDs and possibly moving that to where they do not have to go through. That's really distracting, I apologize. Go through the GMD for their water rights and go straight to DWR, but we will talk about that in a different bill. But I do have a technical amendment. If Chris could pass that out and explain that for us, that would be amazing. This would be a technical amendment to clean up some of the wording. Thank you, maybe? There we go. Let me try this mic. Is this one any better? That one is. Testing, is that better? Okay. Thank you, Mr. Chair.
Okay, thank you, Mr. Chair. So the amendment, main part would strike section 3, which is the water bank statute. This provided that for when a water right is bankable, and in that language it says it's bankable if it's not currently enrolled in active MIFA. According to the intent of the bill, it is to allow a water right to still be enrolled in a water bank while participating in a MIFA. And the thought was that section 3 language would somewhat conflict with that by possibly being interpreted as bankable, meaning enrollment too, so it couldn't be enrolled if it was currently in a MIFA. So by striking that, that statute would remain as is, as in current law. And then new section 2 would just consider that water bank statute when stating that a water right can be enrolled in a MIFA, it just can't be, and enrolled in a water bank, but it can't be withdrawn in the same year or while that right is in a MIFA. In the reverse, that language still would say that can't place in the same year that you withdraw, you can't enroll in a MIFA. So I'd be happy to answer any questions on the amendment.
So basically, the bill was originally written to ban someone in a MIFA from even being enrolled in a water bank per the Attorney General opinion. But after the first draft, DWR decided it was okay to be in both so long as you don't store or withdraw any water from the account while you're in the MIFA. So this amendment just removes a leftover inconsistency from the original intent.
Any further discussion on the amendment? Did I get a second on the amendment? Is there a second on the amendment? Representative Pickert. Is there any further discussion on the amendment? Seeing none, would you like to move your amendment?
Mr. Chair, I close and move my amendment.
All those in favor say aye. Aye. All opposed? Motion carries. We're back on the main motion as amended. Any discussion? Seeing none. Representative Blex, would you like to move?
Yes, Mr. Chair, I'd like to move Senate Bill 205 as amended, favorable for passage.
All those in favor say aye. Need a second on that. Is there a second? Representative Pickert, I believe, was first. All right. All those in favor say aye. Aye. All opposed? Motion carries. Senate Bill 205 will be moved forward. I want to make a quick comment regarding Representative Howerton's other amendment that she was considering to deal with the makeup of GMD boards or the participation of municipalities with GMD boards. I thought that was a big enough issue that we want to address that in its entirety, and we will do that this upcoming year. I think we need to devote a few days to that discussion. So I appreciate the committee's work on 205, and the issue of municipal participation in GMDs will be discussed next year. Okay, at this time, I'd like to introduce David Pope, a past chief engineer of the state of Kansas. Thank you, David.
I'll start again. Thank you very much, Mr. Chairman and members of the committee. It's an honor to have been asked to come and share with you some of my experiences while chief engineer. Certainly as I go through these, I'll dispense with any general background because I think you've already had that about the duties of the position and how that, perhaps how that's evolved. It was somewhat different when I was there, but the basics are still the same. But what I've done is listed off a number of issues that I've described of kind of key things that came to my mind that I dealt with over the years. I think there's 10 or so of those, and there's lots more, but those were kind of key things that I thought might be of interest to the committee. There's lots and lots of other issues, and if you, during our Q&A session, if you have questions about any of the historical aspects of things or what we were dealing with at that point, I'd be glad to respond at that time too, if that's okay. Well, let me just start with kind of an old saying that I'd heard years ago, and it was whiskey's for drinking and water's for fighting over. And that certainly has lived up to its message. We had lots of that over the years. I think in any given time, I was either a plaintiff or a defendant in about 25 cases where people were appealing decisions related to water rights or other issues we were dealing with, or we in turn were taking actions to enforce the law. So we had a lot of activity in that regard, but by and large, really, it wasn't that much of a conflicting period, but we certainly had our issues and our times. I'll just say real briefly by background. A lot of what we dealt with was a product of our layout in Kansas, if I can use that term. Our state varies immensely from the southeast to the west in terms of average annual precipitation, about 40 inches average in the east and down to about 16 along the western edge. Also, lots of other differences. That fundamentally resulted in our surface water use being the primary supply in the east, along with the reservoir systems. And in the west, it was primarily groundwater, mostly the High Plains Aquifer and the Ogallala, of course, some alluvial sources, and kind of a mix in between. And so I want to also say briefly that I found as I was moving into the position and having dealt with water several years prior to that, that we were very fortunate in Kansas to have a really good body of law over the years, water law, and probably a lot of others. As I traveled around over the years to various different conferences and groups that we participated in and met with, I found that to be very true, because a lot of the western states in particular that we have a lot in common with may have started sooner in some respects, although we go way back too in terms of water development, but we had the ability to deal with the issues pretty well. Not to say it was ever simple. Okay, let me move on to the sort of issues that I wanted to say, and quickly, one other point I didn't get to. You know, we deal with, and did during my tenure and ever since, and before, periods of floods and droughts, sometimes both going on simultaneously in the state, depending on different areas. And so there's always challenges, just from the standpoint of the hydrology and the climate and all those things. Now, getting back to my point here, one of the things that I felt was very important when I came to work for DWR, both as assistant chief engineer for 5 years and then as chief engineer for almost, I guess, about 24, 1983 through 2007 were the chief engineer years. When I first started, my predecessor, and I worked with him well and liked him, but he came kind of from an era where he liked to make every decision on case by case. He didn't like to have things bound that would bind him to make a decision. Well, things got a lot more complicated, of course, over the years. So one of the things that I worked on initially when I went to work, along with legal counsel, and Leland Ross was the key legal counsel during my era, very capable individual. We worked together on lots of issues, including interstate water conflicts. We went to work developing, it just became necessary to get things written down for efficiency so people would know what we were dealing with and what the criteria was. We started with administrative policies and procedures. That was before rules and regulations were a common requirement and were not mandated yet for dealing with those kinds of issues. So we developed an extensive body of policies, ultimately got those where we could provide guidance to water users and GMDs and others. That was followed pretty shortly by then a very extensive effort over a period of several years to develop administrative rules and regulations. And there was a point, and I'm talking about in the 1980s now, where the legislature enacting a statute that really provided much more guidance in terms of when rules and regulations had to be promulgated to deal with certain issues. And so we certainly went forth in that regard. So we spent a lot of time in those early years developing a pretty, what I think now is a pretty comprehensive set of rules and regulations dealing with a whole variety of issues. Water Appropriation Act, rules developed and recommended by the groundwater management districts. Also, things like the Water Transfer Act when it came along. Certainly rules related to the water structures area where we dealt with dams and levees and stream obstructions and all of those things, and a variety of other things, levees, floodplain management. So that was a pretty major undertaking for a period of several years. And we developed a pretty comprehensive set of rules, and I'm speaking now primarily of the water appropriation. Whenever I say this, we took out draft rules and had meetings throughout the state and said, this is what we're proposing to do. Give us your comments. This was the informal process way before the regulatory process even started, and I found that very useful. And then we finalized things into actual proposed rules and regulations, went through the hearing process, appeared before a joint committee of rules and regulations, all of those things. And we went through many other iterations of that as time went on, but that was the original big group. And same thing, and like I say, the other statutes that were administered under the authority of the chief engineer. I want to mention here kind of up front also, as I start dealing with some of the substantive issues, that during the early years where I was chief engineer, and perhaps it started before, we saw a lot of change in water supply and water availability in various parts of the state. There was a period whenever conservation practices became implemented very extensively, which is a good thing, but residue management, terraces, all of the different things that happened affected our water supply. And so we were getting less runoff because people were keeping that water on the land and in the soil. That affected the runoff to our surface water systems in the state. We had, I think it's 6 or 7 irrigation districts at the time that were active. These were Bureau of Reclamation projects that were constructed and implemented in conjunction with irrigation districts, which were the beneficiaries then of that water under the Reclamation Act. Many of those ran short of water, and it's very limited even at this point in time. Streams started not flowing. That was a product of not only the runoff, but also groundwater development. That effect of pumping, particularly in the High Plains Aquifer and the alluviums, going west to east, was depleted by groundwater pumping, so we had less stream flow. What's called the base flow component. That's the seepage from the aquifer that goes to the stream. When you lower that water level far enough, you have no base flow. That's where we are on the Arkansas River and have been for a good number of years. It's a dry river. There's no groundwater producing that base flow, and that's true in a lot of our other streams. So we went through that era. Ultimately, early on in my tenure, as we observed all these things and tried to get a handle on it, we did a number of things. First of all, very early in my career, this would have been in mid-'80s, I guess, at the latest, I issued administrative policies that closed a whole series of alluvial valleys in northwest Kansas and north central Kansas. There was a few places affected in southwest to new appropriations of water. They were simply already over appropriated. You could tell that by water levels and by effects on streams. Those areas were later formally closed by rules and regulations as well during that era that I talked about. We worked with the irrigation districts in question and tried to get through that period. All of the areas above those systems on the Solomon River, North Fork, South Fork, Smoky Hill for Cedar Bluff, some in the Republican River Basin. Those were, again, closed to new development to try to protect those inflows as much as part. Those districts had senior water rights. They went way back into the 50s and 60s. Now, this leads into my next concept. One of the early things I did as chief engineer, I think it was mid-'80s, was to adopt rules and regulations that required the safe yield concept to be used for all new appropriations of water outside of the groundwater management districts. At that time, we were still honoring and recognizing their role to develop policies and rules and regs and work with them in their areas. These regulations required consideration of the amount of natural recharge to our various aquifer systems, as well as the contribution of the base flow, the aquifer base flow, to the stream in question. So we not only just looked at the stream, we were trying to look at the interconnected system of surface water and groundwater. This was pretty cutting-edge stuff at the time. This was designed to prevent depletion of stream flow by excessive groundwater use from hydraulically connected surface and groundwater systems to prevent impairment of senior water rights, both surface water and groundwater right, or established minimum desirable stream flows. And I will talk about that a little bit later here. In addition, during about this same time period, Groundwater Management District number 2 and number 5, the two South Central districts, also recommended rules, their own version of the safe yield concept, and those were adopted in regulations recommended by the districts. And so that also got them off to a pretty good start. There were already issues in some cases, but to try to not get into a depletion situation. Now, I want to move into a third point here. When I was at GMD3 at about 1977, 78, I had looked around a lot of other places and realized that there was a need for the ability to deal with these problem areas that were going on. We already had water level declines. There was various things happening. And so we developed proposed legislation that was adopted in 1978 to allow the establishment of what's known as intensive groundwater use control areas, or IGUCAs. You're familiar with that term. So that's where that started. And then after I became chief engineer, or came to work for DWR, that was one of the tools that we had to use. These were primarily designed to be recommended by a GMD, but also in areas outside of a groundwater management district, a chief engineer could establish these with due process on his or her own merit. Ultimately, 6 of these IGUCAs were established in the state while I was chief engineer. And I want to talk a little bit about a couple key ones of those here in a minute. And there were 2 that were initiated while I was assistant chief engineer from the Equus beds, GMD number 2. And those were to deal with some water level decline issues that were already getting up in the McPherson area, as I recall, and also the one down in the Burton area, primarily dealing with water quality issues. And I was very involved in those as assistant chief engineer. There was also an IGUCA that was established below Cedar Bluff Reservoir to deal with the issues there. That's where the city of Hayes wellfield was located. That stream was over appropriated, and we had to deal with how to allocate water there. That was one of the first ones that was really pretty comprehensive in terms of restrictions on how much existing water right holders could divert in a variety of things, including both the city and the irrigators and others. But we also had an IGUCA. We established one above Cedar Bluff Reservoir because one of the issues was the runoff wasn't occurring to get into the reservoir. And we had a process separate from that going through in conjunction with the Water Office and the Bureau of Reclamation to work on issues regarding the operation of Cedar Bluff Reservoir. It got kind of converted. The irrigation project, just there wasn't water for it anymore, the surface water project. And so, but there was a way to try to stabilize it and enhance its recreation capabilities. So that occurred at that time. The other IGUCA I want to talk about, even though there was a number of them we could get into, but the one I think is probably the most important for purposes of dealing with water shortages is the Walnut Creek IGUCA, which is in parts of Barton, Rush, and Ness counties. And that was precipitated by a impairment complaint from the holder of a senior downstream water right for the Cheyenne Bottoms. It's a very senior right compared to almost all of the rights, and particularly all the groundwater rights on the Walnut Creek and the three-county area. This was a pretty big issue. Not because it was Cheyenne Bottoms at all. It was because of their senior water right. A lot of people misunderstood that. They said, this is Cheyenne Bottoms, this was the irrigators. That was not true. In any event, we started that process with a pre-hearing conference, and we ended up having a lot of interest. I think there was about a dozen parties represented by council that wanted to formally participate in the administrative hearing. And the administrative hearings that I held during that time period were essentially like a trial. They were formal. Parties could be identified. They would have the opportunity to present their case, attorneys calling witnesses. We had hydrologic computer models, all kinds of other data and information presented to us by the various parties. Several environmental groups participated as formal parties because they were concerned about the system. And so it was quite a range, agricultural groups, Farm Bureau, some cities, I mean, just the whole range. That process, tell a little brief story, just give you a sense. After the pre-hearing conference, we got the hearing established. We received word back from locals that this is going to be explosive. You better be ready for it. We had reserved a large meeting facility. The first day when we got there, we had police protection. There was about 500 people that showed up for the hearing. And I think they expected this is just we're going to get up and yell and scream and, we'll get our way. And they found out that wasn't the case. And so that was a very orderly process. We didn't have to have police protection for the whole hearing, by the way, where things kind of settled down and people realized the way this was going to be done. We did have, in addition to, I think, 22 days of actual hearing over a period of a few months, and created a formal record, ultimately came up with based on all the evidence and testimony, we did have a public input day as well, in addition to the formal hearing, so everybody could be heard. I heard the case personally, right in the midst of the Kansas v. Colorado trial, so I'd be out there testifying and attending that and come back and hold some hearing in Great Bend. In any event, the order was issued, and it briefly said, we examined that stream aquifer system, and it had watershed projects and municipal, industrial use, lots of irrigation, groundwater, surface water. And we, based on the evidence and determining some things that really hadn't been done in Kansas before, and that was an area like this that would be conjunctively managed between surface water and groundwater. You had to do that for it to work. And so we issued an order. There was a lot of reductions in how much water people were allowed to do, about 50% on average So that's a pretty big reduction in water use. It was highly overappropriated. But we came up with an order that tried to provide maximum flexibility. The first time that had been done in Kansas, we talk now about flex accounts and all. This was the first one that ever in Kansas had any multi-use allocations. So we gave people flexibility. We had the vested rights were not reduced, but they were required to have conservation plans. We developed a category of senior rights, a category of junior rights. And we developed that based on consumptive use requirements, and the juniors obviously didn't get the full amount that was needed for that. And then they were provided with flexibility both in terms of multi-year allocations, but the ability to move water between wells within a farm unit that gave them flexibility that way. So the combination of all of that, economic studies done later by K-State Economics Department determined that the economic impact was very limited. People learned to deal with less water. They used it much more efficiently. They had flexibility. They could use more water in drier periods and less whenever it was wetter. The aquifer came back into balance in just a few years. Base flow was reestablished. The senior surface rights were getting their water. The people that hated my guts for quite a while, and these were some of the people that I knew pretty well in some of my earlier experiences, ultimately came to me and said, you know, this was the best thing that ever happened to us. We're not sucking air with our wells anymore. Now the aquifer's stable, up and down a little bit with climatic effects. We have less water, but we can use it more efficiently. We have flexibility. So I think it was a great success. When I issued the order, I was sued 3 times the first day. They had pre-prepared, the parties on all sides had pre-prepared their briefs. They knew they were going to sue. They didn't even know what I was going to do yet. But, and so we dealt with that for a while. Ultimately, the parties got together and settled the case. And here were the terms. All the parties agreed to accept my order as long as I would give them 1 additional year to implement and get prepared for these reductions. I felt pretty good about it. The local judge, after it was all over with, who was preparing to hear all this, said he had read the record and all of a sudden the damn case was settled. And so, of course, he never had any hearings or did anything. We did have a lot of enforcement issues to deal with, and I had a number of people said, you know, man, you know, this is tough, but they finally said, you know, if you'll enforce this, everybody was metered, of course, required to be metered. If you'll enforce this, we'll go along with it. But we don't want somebody over here pumping extra water and nothing done about it. And so we did enforce it strictly. We went out, there were some tough cookies in the area, and we had to go out with the sheriff a few times. Our staff did. But ultimately, everybody came into compliance. Now, I spent more time on that than I probably should have. I want to move on to, we'll have time for questions here, hopefully. Another point is, I worked with an interagency group, including the Kansas Water Office and Department of Health and Environment, to develop minimum desirable flows, the actual quantitative, the numbers, that were then presented to the legislature. And this was on 23 different streams around the state. And the first bill created a priority date of April 12, 1984 for the minimum stream flows. It was like a water right, basically. So any permits that were issued after that were junior to the MDS. Those were established in law, and we have had a pretty successful run, I think, of administering minimum desirable stream flows when we get into low flow conditions in various different systems. Most of these are in the the eastern half of the state, frankly. But so that was another thing I was involved in, and good interagency cooperation there. The next point I want to get into is when early in my career, there had been a requirement that water right holders would keep track of their use and report it to the state. The trouble was, at that point, essentially none of them had water meters. They were trying to keep track of pumpage by hours and then the rate of flow. They weren't taking it very seriously. We only got about 60% of the reports, and we had no enforcement capability to do anything about it. That began the area of getting better water use information in Kansas. We worked with the legislature to pass KSA 82A 732, which then required the holders of water rights to keep records and to report their use to DWR, and gave us penalty authority and the ability to enforce. In a former life, Lane Luterner over here, before he became the big dog he is now in DWR, he handled our water use program, did a fantastic job. We went through an era where we started requiring meters, first on all new permits and changes to existing water rights, and then ultimately, essentially everybody. And some of that was done in conjunction with the groundwater management districts who had metering requirements. The combination of the authority to deal with water use, reporting, and measurement, all of those things resulted in really good information in terms of how much water is being used and where and how to deal with it. The system has, continued to be enhanced with additional metering and all the things that's happened since I got out of there. I'm told from some sources that Kansas, with USGS and lots of other sources, has the best water use system in the country in terms of records and that sort of thing. Moving to the next point. We had an issue in eastern Kansas with the use of water below several of our federal reservoirs in terms of how they were operated. And the Corps of Engineers had their criteria and when they were going to release water. Obviously, flood control is their deal in terms of when they have to do that when talking about low flow releases for what they called water quality purposes in some cases. The agencies got together. This was when Joe Harkins was director of the Kansas Water Office and was really a kind of a conceptual guy on a number of things. We had a summit with the kind of stakeholders on this sort of thing, and ultimately the agencies working with cities and water districts and others came to the legislature and asked for the Kansas Water Assurance Program to be created. That's 82A 1030 through 1348. We developed rules and regulations for that through our office related to the water rights part of it. But the concept was to allow each of these several river basins in eastern Kansas to be operated as a system, the reservoirs to be operated as a system, instead of willy-nilly, one here and one here. So we had to work with the Corps of Engineers. The state had state-controlled storage in these reservoirs, so it had the capability. Some of that water was not marketed, so it was available, and the water assurance districts that were created under this law could contract for additional storage. So now, when you take the Kansas River as an example with Milford, Tuttle Creek, and Perry, depending on flow conditions and what's needed, water can be released to maintain target flows, the Kansas River, that will meet all of the municipal and industrial users' needs who are members of the Water Assurance District, and also make sure target flows are met for environmental and water quality purposes. This, in my view, is one of the huge successes in terms of surface water management, and Kansas is viewed as the leader. No other state had done anything like this. We had good cooperation with the Corps of Engineers. We fortunately had the water marketing program. We had some unmarketed water and reservoirs that could be used for this. The beneficiaries pay for the water that they acquire from storage. Okay, moving on. I want to switch to the water structures area here for a minute. This is a program that handles permitting of dams, inspections, dealing with high and significant hazard non-federal dams. I'm not talking Tuttle Creek now, I'm talking about the state permitted dams. Early in my career, there had been a series of failures of dams in the country. Some back east, Lawn Lake Dam out above Estes Park in Colorado. And I had a relationship with most of the state engineers in the West through a group that we had created and worked with. Had been created long before. And so it was pretty up to date on what that. A group of us got together and created what was known as the Association of State Dam Safety Officials. And we met, tried to figure out what to do about dam safety, learn from each other, worked with the federal government, the Corps, the Bureau, NRCS, others. Ultimately, and at the time, Kansas had about 500 what was later determined to be high and significant hazard dams. Now, what I mean by high hazard is if the dam is to fail, there'll be loss of life, or could be. Significant is kind of in between. There's damage can occur to infrastructure, potentially some loss of life. So these are serious issues. We were able to get the federal government to get some help from the Corps of Engineers, and they provided some initial funding to allow states to staff up to conduct inspections of high and significant hazard dams. So we had a team of people that went out. Some of these have never been inspected since construction. Now, DWR had required inspections during construction for many, many years, but this is periodic inspections thereafter. Dams have to be maintained, otherwise you're going to have problems. And some do have problems, or did have. So we got all of the dams inspected. We worked with the owners to get problems fixed. We started having dam safety conferences that where owners could come in and learn and get information. So we tried to network with people and work with them. Some would not, others, vast majority of people tried to do their best. We did have a few cases where they pushed back, and I have some vivid memories of at least one case where it went all the way to court, and ultimately the guy had to be, the judge ultimately told him after he refused to do what was needed and fired his engineers and that he was required to hire, and I testified in the case along with our experts, and the judge, I remember telling him, he said, when you come back here, and he set a deadline, if you haven't fixed this, bring your toothbrush because you're going to jail. Lots of memories. Okay, moving on. Along the way, right about the time I became chief engineer, we had serious concerns about flows of the Arkansas River, western Kansas. You know where I'm going with this. The river had dried up. We weren't getting the water that we thought we were entitled to. We hired an outside engineering firm to do some study and analysis. Surface water had been used for 100 years, you know, but in the 50s and 60s, a lot of wells were developed, both in Colorado and in Kansas, along the alluvium. And those, somebody once used the analogy, it's kind of like sucking it out from the bottom. So when you pump the water, it depletes the river and you don't get it to Kansas. And it was affecting Colorado too, but they ultimately started dealing with theirs a little bit along the way too. So we started complaining of I was a member, as an aside, the state agency member of each of our 4 interstate river compacts. This was the Arkansas River Compact with Kansas and Colorado. We also have an Arkansas River Compact with Oklahoma, by the way, where I grew up. That was always interesting. And a guy I knew down there that grew up in Kansas became the director of the Oklahoma Water Resources Board, so that was kind of interesting. We got along okay. So I digress, but so we finally asked for, we did our homework. We asked for, as required by the Ark River Compact, for administrative investigation under the terms of the compact. And so we started meeting with Colorado. This was pretty early in my career again, I think probably by 84. I think we met monthly for about a year and did the best we could. We didn't ultimately make much progress, and Colorado had refused. They said, oh, the problem is just like a runoff from the uplands, and we knew better than that. It was groundwater pumping, and they refused to admit that that was the case. So we got with the Attorney General, it was Bob Steffen, the late Bob Steffen, and he filed suit in the U.S. Supreme Court to enforce the terms of the compact. That was probably around 85 or so, and 85, 86, I don't know, something like that. Oh, here I've got it, December 16, 1985. So that led to one of the most time-consuming issues I'd had to deal with in my career. That case went from 1985 to 2007. Guess what? That's when I retired. The last thing that had to be done formally through the court and by the states was done just a few days before I retired in 2007. And my counterpart, the state engineer in Colorado, retired almost exactly the same time. We both had kind of had it. That's not totally true. Anyway, to make matters short, we went through various different phases. You had to get permission to sue them. We had to do all kinds of things to get ready for trial, discovery, all of that stuff, and depositions. Ultimately, the trial, the case went to trial, and that was about 280 days of actual trial in the courtroom, along with all the hearings and trips to the U.S. Supreme Court. This case was heard by a special master appointed by the U.S. Supreme Court. He's the trial judge. He hears the evidence, makes recommendations to the court. And this case was phased into liability to see if there was a violation, then remedies. What are you going to do about it? What kind of remedy? Is it going to be water or money, whatever it is? You know, all kinds of different, what are we going to do about it in the future? So all of these different segments of the case. And so during that essentially 25-year period, I spent an awful lot of time doing that. And we'd go out usually for about 3 weeks of trial, come back and have a week off or two, and go back for another 3 weeks. Just went on and on. And then there'd be breaks where the case was, once a special master would write a report and send it to the U.S. Supreme Court, either state could take exceptions to anything in the report, and that would result in the court scheduling oral argument, and the states could present their arguments. So we went through that about 6 times. So I got to spend a fair amount of time sitting in the audience of the U.S. Supreme Court and working with our team. We ultimately were quite successful in the case. It was a knockdown, drag-out, but we didn't get everything we wanted, but we did get injunctive relief against pumping that was violating the compact. We got ultimately about $35 million in economic damages for the past violations of the compact. You know, there's a provision where water users can't sue water users in another state. Only the state can sue another state to rectify that situation. The concept was that their losses would be calculated, and they were. It was probably minimal compared to what it probably really was, but economic damages to the water users and all the indirect things for past violations of the compact. So that's kind of where we ended up. About $10 million of that 35 was appropriated to, there was a special fund created for this money, and about $10 million was appropriated and given to Groundwater Management District Number 3, the local entity out there that, and they're working with a lot of projects and things to deal with that, to improve. The goal was to try to get money out there to improve our system, the ditches, the head gates, the better conservation, improvements to Lake McKinney, all the different things that needed to be done. So some of that's been done. To my chagrin, and I shouldn't probably mention this, but I guess I will, lessons learned. During the dark of night, on the very last day of a legislative session after we got this money in, somebody decided we need to transfer $25 million of this to the general fund. Last day about midnight. There wasn't anything on the agenda that wasn't even in the either thing that came from either House of the Senate, and just did it. One of the low points in my career. I got to move on. I want to also talk a little bit about our issues with Nebraska. I also played a lead role in the Kansas versus Nebraska and Colorado litigation, which commenced January 19th of 1999. Ultimately, before the case went to trial, there was a special master appointed. We did have a number of hearings and gave him tours of the basin and all kinds of things, but the parties ultimately agreed at the request of Nebraska to enter into settlement discussions, and we did that. I led the settlement team for Kansas, which was myself, Lee Rolfs that I mentioned earlier, David Barfield, who at that time was our interstate water management engineer, and we had outside counsel, John Draper, and other technical experts that helped participate, people that did the modeling and all kinds of things like that. So ultimately, the parties were able to reach a settlement, which we thought was fair to everybody, and it was submitted to the special master in December 2002. And so we felt like we were in pretty good shape. Well, unfortunately, there were some deadlines and lots of limitations of what Nebraska had to do or couldn't do, and Colorado, although Colorado wasn't the primary culprit in this, it was Nebraska. And so at the first chance possible, Nebraska violated the terms of the settlement. And that required Kansas to take it back to the U.S. Supreme Court. This resulted in more trial before another special master, and some arbitration provisions that were required by, I forgot to mention, by the states. We did that. And then wasn't totally resolved at the time of my retirement. Dave Barfield then picked up where I left off. I will say after my retirement and we were down the road a ways, after arbitration and everything, well, I guess this included arbitration, but then I got called back to testify based on my historic knowledge of the case and what had happened and all of that. At a couple of arbitration hearings, as well as the trial that was held by the, I think this was the third or fourth special master that we dealt with in between two cases. And it was more of a limited role, but I did testify about the historical perspective on that. Anyway, we ultimately didn't get everything we wanted, but we did get several $1 million of economic damages. Nebraska was required to do certain things. Ultimately, over a period of time, and a lot of this happened under David Barfield's and his staff and others, ultimately, Nebraska got in compliance. And I think things are in pretty good shape now. So all this interstate water stuff we spent a lot of time on. The good news from my perspective, as best I understand it, is both Colorado and Nebraska are in compliance. The disputes are over. Parties are working together. They're collecting data, having their regular meetings, evaluating things. And my sense, not personally involved, but my sense is that we finally turned the corner on that. I'm going to see what I missed here. I think that, I don't think I mentioned, but one of the things I was talking about dams earlier, and I skipped over this point, I'll just add it in right quick, is I talked about the dams, but we actually established then, after we got the one-time inspections done and determined which were problem dams and dealt with those, we established an ongoing periodic inspection program for all significant and high hazard dams. So like every few years, depending on the situation with the dam, our staff would go out and inspect the dam to make sure it was in good shape still, deal with any issues. I think they've now kind of privatized that program, as I understand it, where the dam owner is required to hire a licensed professional engineer and do the inspection and submit the report to the office of the chief engineer. So it's essentially the same thing. But okay, I'm going to pause there. I know I probably missed some things, but we should have some. I want to allow certainly time for questions, if you want to.
Are there any questions? I've got lots of commentary here. This man is one of my heroes. He had faced some very serious conditions in Kansas water history, and I applaud what you and the Division of Water Resources did during like 20-some years plus there. The wet walnut deal with the IGUCA concept that you came out with, which was similar to the one that you had in GMD3. In many ways, I see some similarities. The wet walnut going to Cheyenne Bottoms and then the Quivira issue. If anybody would like to speak to that, but I see some very similar conditions there and possible solutions.
I want to interject one thing. Thank you for your comments very much. One thing I had in my notes and I didn't get it said. I spoke a lot about what I did and the role of the chief engineer. One thing I was going to try to emphasize was it wasn't just me. The staff, Lane and lots of people like that did a wonderful job. We worked under challenging conditions, understaffed, and all kinds of things over many years, and the agency should be very proud, and I think the public, of the work that the entire team of people did, including the staff out in the 4 field offices that are the people on the ground that work with water users and do inspections and enforcement and work with GMDs, all the different things that occur. So it's really a good group of people, obviously changed over time with, you know, some of us finally getting retired and others along the way. But so I always enjoyed working with the staff. They were very dedicated public servants.
Representative Howerton.
Thank you, Mr. Chair. I would just like to thank you for your testimony, and I hope you write a book because firsthand account of history is very important, and there's a wealth of knowledge in history. Thank you. Thank you. So just thank you for that. And it's also encouraging to me that if you do the hard thing, I think a lot of people are opposed to change, but sometimes change is necessary, and doing that hard thing may not make you so popular, but in the end, it's what's right and what needs to be done. Thank you.
Thank you so much for your comments. that book issue's been mentioned a number of times, and that was my intent, but unfortunately it hadn't occurred yet, but I guess we'll still hold. We'll see.
Representative White.
Another comment bouncing off those guys. I was innocent bystander 100 miles away, but I knew what was going on, or at least I heard of the Walnut Creek. You know, it was started out to be a fiasco, and it ended well. And I want to tell you, there were people watching from southwest Kansas saying, wow, look what happened. But I have a quick question. What year was that $25 million appropriated by the state? Can you remember?
Do some research on that, but I'll try to get back with you on that. I think it was, yeah, something like that, probably, yeah.
Did it ever come, one more question, did it ever come back to water? It poof. Okay, thank you.
Representative Vaughn.
Thank you, Mr. Chair. And I'm so sad that I missed the beginning of your presentation, Mr. Pope. I'm going to have to go back and watch it. I don't know if the chair excused us. We had our water funding bill hearing in the Senate this morning, so we were paying close attention to that. But I also wanted to reiterate all the comments that were made this morning and second the idea of you writing a book. I would definitely read that. My question was about the Ark River Compact. I know right now we're seeing a lot of issues with the groundwater quality, and I was wondering, did the quality concerns ever come up in the original compact conversations, or is that kind of the uranium and selenium, is that something that we're seeing more recently?
It was not an issue during the dispute that we litigated. It's not that we were unaware of that, and I remember some informal discussions. The uranium thing, I don't think we were aware of that, but there was a salt load. That was the big thing at the time, because as water's used and reused in Colorado, and that's just the nature of ditch irrigation and the way things work, you get this concentration of salts. And so that came down the river, and that was a concern. Ultimately, it didn't get included in the litigation. I think some of us would have liked to have seen that, but I think it was viewed as a step too far for the circumstances we were in. But there are a lot of ongoing activities now, I think, between the two states, and both states have the problem. I'm not very close to that, so.
Yeah, that's really interesting. I was just kind of curious on the background on that. And then we've talked about this a little bit, but I know we're talking about, especially with the drought on everybody's minds, the need to conserve this crucial resource and the fact that it's largely non-renewable. And we have a lot of districts who are doing a great job of this, and we have some districts who are still kind of bringing along. And I was wondering when you were doing the different IGUCAs and working with producers, what was that, like, how did you change the mindset? What was successful for you in terms of sharing the benefits of conservation? And on the other side of that, when the producers did the conservation and instead of pumping air, like you said, they had water, what was some of that feedback that you received?
Okay.
That's kind of a broad question, but just opening it up for more discussion.
Well, in the specific case, I think you mentioned IGUCAs. The IGUCA process is very different from the LEMA process. And when, for example, particularly with Walnut Creek, but it was true to some extent in all of them, I was sitting as a trial judge. So there was no discussion by me personally with any of the parties one-on-one, no informal stuff on the side. So it was simply holding the hearing, creating the record from what was provided, and then ultimately making a decision. But so it's a kind of a top-down process, unfortunately. Now, if it had been, in some cases, that one was mostly outside of a GMD. A little part was in GMD 5, but they didn't really take a strong position. But that was one of the things we learned, I think, over time is it's pretty much a top-down regulatory situation. And now you can have all kinds of studies and things done in advance, and parties can talk to each other and all that. We actually did create two teams in DWR, one that was my counsel and assistants, and a separate group that could kind of work with users and provide information they needed, things like that. They weren't an advocate or anything like that, but so there was some linkage that way. But Of course, in contrast, the Lima process involves, and that was one of the things that came out of that, was we'd like a process where we're more involved on the front end and all that kind of stuff. So I don't know whether that totally answers, but yeah.
Yeah, that helps. Thank you.
Representative Blacks.
Thank you, Mr. Pope, for your presentation. I appreciate the history. I retired in wildlife and parks, and I remember working with some of those issues, particularly in the dam safety, state fishing lakes. I guess a couple of comments. One, the previous representative, one good way to persuade people is bring your toothbrush. And and I do appreciate that work that was done then, but in recent, and we're seeing that potential sweeping of that potential long-term funding that this committee wanted into a situation where now another body wants to allocate it chinkle at a time that's subject to gone. And that's the importance of the message we need to send, that a long-term funding commitment is critical because we have such a past history of that being swept in one way or the other. And I guess a year or so ago, they talked about putting the chief engineer as an elected official. What would be your opinion of that? There was a big push within the legislature to have someone that was accountable to the people. And, I worked, and our agency worked with you in a situation where you was almost a czar in a lot of ways. And that wasn't necessarily a bad thing. And we're hearing today, you got a lot of good things accomplished. But, I mean, what would be your opinion of that if that were to happen?
I will say incidentally that I did spend a lot of time during my tenure going out and speaking to groups and meeting with groups on the informal side of things, so it wasn't just sitting in the office making decisions all the time. So there was a lot of attempt to try to get out there. I was speaking of those formal decision processes like in Iguka, but now having said that, I really think the position of chief engineer is best kept pretty much as it is in the classified service. I will tell you that there were lots of occasions where people would attempt to apply political pressure, whether it was down through the governor's office or legislators or whoever else, interest groups, all those different things. And I did my best to ignore that. I can tell you that my life was threatened at least once, and there were some pretty rough times. But I once was real busy and I didn't have much time, and this guy came in that was just had to see me, and I said, I don't have any time, and he said, well, can we grab a sandwich together? And I said, well, I guess we could do that, and went over to a place near the office and sat down, and I insisted, of course, I buy my own sandwich. And then we were sitting there at the table, and he started pulling out this handful of bills. I just stood up and got the heck out of there. I mean, that's the kind of thing that I wanted nothing to do with, and so you've got to have somebody that can stand up to a lot of stuff, and it's probably not perfect, but I think making that position a political appointee or elected even, or whatever, maybe elected, I guess, in theory, but I think it'd be a disaster.
Thank you for that. Thank you, Mr. Chair.
Any other questions? Representative White.
Thank you, Mr. Chair. Was that water bills getting close to 25 million?
What's that?
That water bills that he was,
Oh, no.
I would have loved to,
No. We're
I'd
talking
have
about
loved to
small
know the
change in
squeal point.
he was just trying to bribe, and and so, I just tried to play it straight and narrow. Wasn't perfect or anything, but yeah, there was interesting experiences over the years. So,
I have a question for you, sir. With your vast knowledge and past experience with all the water issues here in the state of Kansas, do you have any suggestions for the people of Kansas and this committee on some future things or things that you see on the horizon? I'm looking for your crystal ball predictions here, and if you could give us some insights, I'd appreciate it.
Well, that's a pretty challenging question. It's a good one, of course. I'm very pleased with the action this committee and hopefully the full legislature. I didn't get a chance to check the latest status, but with the bills that you've been working on, and hopefully those will end up in law. I think it's just absolutely essential that action takes place just as soon as we can to deal with the issues in western Kansas and lots of other places. But, you know, we've done a lot of good things. I think it's we, not just me, and have good statutes. I think the agencies try hard and do a good job to deal with water. And nobody's perfect, and including things I wish I could have done. But I think a lot of good things. We have a good planning process. The policy, you know, when I started as chief engineer, it was the same time that Joe Harkins became director of the Kansas Water Office. And there had been a history of, for all practical purposes, conflict between the old Water Resources Board and the DWR. And I shouldn't say outright conflict, but it just wasn't working well as it should have. Then things started happening in 1981 with reorganization, and by about 83, then the governor brought in Joe, and I became chief engineer. We sat down and talked and just said, we've got to work together. There are some real challenges here, and we did. And so the process he developed to develop policy and planning and all the things that take place under the responsibilities of the Water Office that was then created and what we were doing. And so he said, it's your job to carry out and administer the laws. We'll try to develop policies and legislation and the water planning stuff. And the process really started working very good, I think. And I think a lot of good things have happened out of that. I really don't have any complaint about the structure. Some people do. Probably could be improved, but I've seen lots of examples in other states, and I've worked with most of them over my career, that things can really get balled up. So be real careful. That doesn't mean we're perfect, you know, and all that. But so the real issue is just to roll up our sleeves and get it done. Get the work done. The funding issue is critical. That's very encouraged to hear that. And, you know, there are lots of problems. As much as we've done over the years, there's lots of problems for the future to deal with. I'm not sure whether I got to your question right, but was there another part of it?
Oh, you did very well. Are there any other questions from the committee? Representative Pickert.
Thank you.
Yeah.
Honestly, for what was accomplished, it seems to me that would be really helpful to other states and just appreciation of the history, but how do you go about doing it?
Yeah.
Your perseverance, your integrity, your work ethic, that's very much appreciated.
Yeah. Thank you very much. I learned my work ethic from my parents and values and honesty, and just was very fortunate in that regard. And they believed in education. They grew up in the Depression and middle of the 30s when they got married and didn't have anything. And grew up on a farm in Oklahoma. Went to Oklahoma State. So I've been very fortunate. But yeah, I appreciate your comments, and I do have a copy of my comments, both electronically and written, to give to Tony of the outline, and be glad to work with with the committee and anybody on this stuff. Well, thank you very much again. But
Committee, would you join me in a standing ovation for this guy?
oh my gosh. Thank you.
We're trying to start a new tradition in this room.
I'm very honored. Thank you very much. I appreciate it.
Thank you very much. Can we get an update on our House Bill 2302 over in the Senate, please?
Amendments on 2302 so far today, as I go through the list. Let's see, there was an amendment to strike, to change the funding source to SGF transfers instead of sales tax. That was defeated 5-4. There was an amendment to remove the reservoir payments because there's a corresponding budget piece to pay off the reservoirs in full. That was approved. There was an amendment. Which one is this? I lose track of all of them. It was a busy morning. They did change the cap on the project grants fund from $45 million to $30 million, and any spillover from the technical assistance and project fund would spill over into the state general fund rather than back into the water plan fund. And then the other piece was a directive to the water authority when they deal with the fees collected on stock water, that they focus those funds on conservation projects specifically for stock water. So that wouldn't affect any of the new money that we put in on our bill. So I believe there are 2 or 3 more, mostly minor things for them to get to tomorrow morning, and hopefully they'll pass it out. But mostly the bill is intact as we passed it out. So I think good progress today.
Do you think they're still going to be working it on Thursday? Potentially?
I wouldn't speculate on Senate time, Mr. Chairman.
Okay, I want to commend this committee on the work you've done this year. Tony's been trying to put together our presentations, the book of all the things we've done, and it's what, about 5.5 inches thick. There are 2 brown folders about this thick each that on presentations that we've had over the last 22 sessions. You guys have done great work. I think over in the Senate, they're about 1/2 inch. They're about 7.5 inches behind us if we want to talk rainfall or knowledge in a lot of ways. But I want to commend this committee on the work that you've done this year. I will cancel the meeting for Thursday with the anticipation that they might still be working in the Senate. I would encourage everyone to go over there at 8:30 on Thursday if we need to help push this thing through. But I wanted to thank the committee for your efforts this year. Anything else for the good of the committee? Cautiously, Representative Vaughn.
Thank you, Mr. Chair. This will be quick. I just wanted to wish everyone a happy World Water Day. It's the water day that the United Nations sets to raise awareness about the need to conserve water and have clean drinking water and sanitation available for people all over the world. And it's only the 2nd time in the United Nations history that they've held a World Water Conference. So a lot of people are aware and becoming involved in water issues in Kansas and outside of Kansas. So I think Water Office and other people are in the first floor rotunda and have some information about World Water Day if folks want to check it out.
Anything else, committee? We are adjourned.